Okay, we're here on the case of Garcia versus Security First, 21-1456. We have one oral argument scheduled this morning. You'll each have 20 minutes aside. There is a clock to help you keep your time. If the appellant would like to have me, help you reserve time for rebuttal, I'll do that. How much time do you wish to have?
5 minutes, Your Honor.
Okay. This oral argument is being live recorded, so the public does have a chance to view it. Let me go ahead and introduce the other members of the panel. We have Judge Jay Cohen and Judge Erica Eisnagel. If you do have a cell phone or any other electronic device, make sure it's in the silent mode so the oral arguments are not interrupted. And with that, I'm going to try to mispronounce your name probably. Ms. Yassi?
Giassi, Your Honor.
Yassi.
Very close.
Okay.
Giassi.
You may proceed.
Thank you very much. May it please the court. Good morning, Your Honors. I represent appellant Mariana Gracia. The issue before the court this morning is a summary judgment that was entered by the trial court on the purported violation of my client of what we call the concealment or fraud provision in the insurance policy. We've argued several grounds for reversal, but I think the two threshold grounds that I want to focus on is one, this record is replete with facts that establish there was not a false statement made by Ms. Gracia. And second,
let me ask that. Let's start with that. Your client represented that the condition of the roof was good.
Correct.
That was not accurate, was it?
I don't think that is inaccurate, Your Honor, and there's multiple record sites throughout the brief that
let's start
that
with
position.
The fact that there was there was a home inspection.
Correct.
That showed the roof had problems. Now I know there's a dispute as to whether it was in the fireplace or other portions of the roof, but you're not seriously contending that there weren't problems with the roof and that it wasn't in good condition.
I am, Your Honor. The question was, and just so we don't confuse the issue, the question in the deposition to my client was, what were the results of that home inspection report, to which homeowner stated everything was good. So just starting with that alleged false statement, I think it's perfectly reasonable.
When you're talking about a report for a purchase, home purchase, if you said it's good, does that mean it's satisfactory or it's perfect?
I think that's a great question, and that's one of the arguments that I raised in the brief. I have dealt with home inspection reports in the past where the different areas that the home inspector inspects are related as excellent, great, needs improvement. One of the points that we make here is that there was no specific rating as to any area of the property. There's no statement made by the home inspector that this is good, this is bad. So
let me ask you this. Does the record reflect who hired the home inspector? Was it the lender or the homeowner?
It does not, I don't think. It might be somewhere in the deposition testimony of the insured, but typically I think she testified it was in connection with the closing. So it was required by her lender and she would have hired the homeowner and paid for it.
What was the purpose of the report, regardless of who hired the inspector?
Typically, I don't know that it's necessarily part of the record, but the purpose of the inspection was to put her on notice of any discrepancies with the house or the condition of the house, and it's typically required by traditional mortgage financing.
Well, if were any repairs required by the lender based on the report?
There is nothing in the summary judgment evidence that suggests that, and that's one of the arguments that we made, having personally purchased a house and had a home inspection and had my lender say, okay, you need to repair X, Y, and Z. There's no evidence in the record, which I think leads to a very fair inference.
No, but the other part of a home inspection is to allow the purchaser to make a decision simply whether they want to go through with the purchase of the property. It's got really, it might not have anything at all to do with the lender.
I agree. It can be twofold. Sometimes it reveals information that if the homeowner's within a certain inspection period, they can cancel without penalty. But the same thing goes, that it's also something that's provided to the lender in connection with the final underwriting and the approval of the financing. So there certainly are situations where repairs are required by the lender prior to the underwriting approving the loan.
So
And
I guess my question is all of this sort of discussion being had, do we look at your client's answer in deposition in the context of, well, we were asking, the question was about an inspection report, pre-purchase inspection report. Or should we look at it from the different perspective, maybe of an insurance company's perspective?
I would ask the court to clarify that question just a little bit.
Well, did your client think that it was good and then therefore moved in, or did she think it was bad and therefore didn't move in? Did she buy the house?
She bought the house.
Okay. Is it possible that her response was saying, "Oh, it was good," was her sort of analysis, and therefore I moved in, sort of thing? I mean, isn't
It's
that the
possible,
point?
and that's one of the, I think that's one of the things about this record. When you look at the actual two questions that led to the forfeiture of coverage,
They're pretty vague, right? The questions in
Yeah.
deposition are kind of vague. Let me ask you
They're
this.
very vague.
I think another, perhaps the stronger case for summary judgment is just, was the property already damaged in these areas as evidenced by the inspection report? What part of the inspection report do you think is worst for you as it relates to the roof, any roof problems, or any ceiling problems identified in the 2015 inspection report?
So, and that's kind of one of the points when you look at the question, the second question, what was there any mention of the roof at the house? And she responded by stating the roof is in good condition. And when
I'm
you
not
look
asking,
at,
I'm not really asking about the
Oh.
deposition now. I'm asking about the evidence of damage as indicated in the 2015 report,
right,
and the notion that indicates that the damage that's being claimed in the insurance claim was pre-existing.
so there was not summary judgment entered on pre-existing damage. There was summary judgment entered on the fact that she testified that the condition.
Let's say for a moment that I read the summary judgment order a little differently than you.
Mhm.
And let's say for a moment that the summary judgment was entered on both grounds. Can you please identify for me what you think in the inspection report as it relates to the roof or the ceiling is the worst part of your case?
So the worst part, I think, is where the chimney said, they noted that
The chimney area?
Right, which again was not specifically one of the questions asked by counsel during the deposition.
Let me
But
ask
you
you this,
also have you have to
counsel,
compare that.
if the
Sure.
inspection report clearly reflected damage that then your client 2 or 3 years later clearly attempted to make a claim for, and we had evidence that was very clear the damage was exactly the same, would that not be a false statement or concealment and fraud?
If we had evidence that it was the same damage, and if
Right.
we had some sort of concession like there have been in other cases, yes.
I don't know that there needs to be a concession. If we had clear evidence, pictures in 2015, when was the event here? Allegedly 2019. So we had pictures from both dates. They clearly show indisputably, right? Indisputably that there's the same damage. If that were the
disagree.
case, no. If that were the case, then there couldn't be summary judgment, you're saying?
I think that if the court is asking me if there were two pictures and if there was, an expert that opined that it was the same damage, then potentially yes. If she had, but I'm still, I think that, so you're asking me about the grounds that some of the damage or potentially, some of the damage, we're kind of talking apples and oranges here. So if some of the damage was pre-existing and there was an expert that opined to that, which we don't have here. In fact, their own expert report, I think, says the damage was consistent with a single or limited number of moisture intrusion events prior to our inspection. That's the only conclusion reached by Security First's expert. So if we had a picture and we had someone who inspected it and reached the conclusion that this was the exact identical damage, maybe there should be a basis for summary judgment as to pre-existing damage as to that portion of the roof, but that's not what we have. What we have is Security First.
You wouldn't have fraud or a false statement there.
Well, what would be the basis of the false statement?
If a claim is made that this damage was caused in 2019 and there's proof that it was actually caused in 2015, that wouldn't be fraud or a false statement.
If there were, it was a April of 2017 claim. Yes, to the extent if there was evidence to support that, but there's really nothing in the record that that supports that. The expert affidavit from Security First doesn't support that. The testimony from even the home inspector doesn't support that. The testimony from the homeowner doesn't support that. And also, when you go through the home inspection report, and before we even get into the fact that the judge here completely weighed the evidence, looked at the photos, acted as a fact finder, and determined that Ms. Gracia's statements weren't credible, we have to look at the exact statements that she's being tasked with making. So I think to some extent there was no summary judgment sought, or I don't think it was ruled on. The judge makes it clear in the order that the coverage was forfeited based on the material false statements. He doesn't say that the damage was pre-existing.
Let's get to the kind of broader issue here, which is your argument that there has to have been an intentional misstatement. That is your position, correct?
Yes, Your Honor.
The one hesitation I have with that is this idea that in order to defeat summary judgment, all you have to say is, I didn't mean it. I don't know if you read a recent opinion that I wrote where I talked about that in a different context of a negligence case. But you understand, my concern with that?
I do understand your concern, but I think, and that gets more into the facts of the recent cases from the fourth, the Triff and the Yolanda Vargas versus Safe Point. I maintain here that homeowners saying that what were the results of the home inspection report? She stated everything was good. Going back to no repairs being required by her lender, that's a reasonable inference. She testified that there were no issues at the house. There were no leaks. She never had plumbing issues. And then when she's, the second statement, and these are the two statements relied on by the carrier during their motion for summary judgment, and the two statements that the trial court hung his hat on when he decided that the photographs were conclusive evidence that Ms. Gracia was not telling the truth. She testifies generally that they didn't put the report in front of her. You look at the disclaimer in the report, you look at the roofing specific section of the report, it has no problems identified. You have to go to the chimney portion of the roof. So I think that goes to some of the very vague questions that were asked during deposition that just kind of exploded into this, accusation that there had been some sort of false statement. So, I don't think that there was a false statement made that is supported by the record. There's conflicting opinions. There's conflicting evidence from both the A and B report, the A and B.
Yeah, but isn't your position though, even if there was a false statement, there had to be some sort of intent to defraud?
Sure, absolutely. And when you look at the facts of Anchor versus Triff, I think that that's, consistent, and it's going back to, the case from the Florida Supreme Court, the Dickerson case in the 1920s. Here we are dealing with, post-loss conduct. You look at this in the context of, motions to dismiss for fraud on the core, bad memory, that sort of thing, it certainly doesn't rise to that level. And I submit that it shouldn't rise to the level of forfeiting what would be otherwise valid coverage. Triff, just briefly, there was an estimate that was submitted pre-trial for
We're
six
familiar
figures.
We're familiar
Okay.
with the facts of
Let me
that.
ask you this, does a ceiling which reflects water damage mean that the roof at that time is bad? Or does it
No,
mean
not
that the roof
necessarily.
at some time was bad?
Yeah, and in fact, the the home inspector, when he was deposed, he said that there was no way to know whether that was leaking. He confirmed that there was no active leak or moisture present on the day of the inspection for that resulted in the A and B report. Whereas in the proclaim report, the expert report that was filed by the defendant, they noted that there was moisture present. So, the home inspector conceded that these types of damages are often covered up. He didn't notice an active leak. I just again, focusing on the two questions that were determined to be false. I think those are threshold issues that this court has to say there is not a doubt in this record that those questions were false. And I think the questions are overly broad, general, and I think that they're supported, and especially getting to Mr. Cooprider's testimony when he was asked specifically about the A and B report, and this is on page 1087 of the record.
Well, but his report was really of very limited value. He said that, he was at a disadvantage because the damage had occurred so much earlier than his report.
Right, Your Honor.
I don't know that his report is of any real significance.
It might not be when it comes to causation or, the date of the loss, but he specifically testified, again, this is on 1087 of the record, that he reviewed the A and B report and quote, I didn't see the same issues that were reported here, which bolsters the fact that, Ms. Gracia did not make a false statement. And again, just
4 minutes and 6 seconds. I don't know if you want to.
No, I'll reserve the rest for rebuttal. Thank you very much.
Thank you.
Your Honors, may it please the court. Angela Flowers of Kavicki Draper on behalf of Security First Insurance Company. And I think it's appropriate that I begin with reference to the correct summary judgment standard under the amended rule 1.510, which was applied in this case. And I filed a notice.
Does the judge, we're familiar with the rule, but does the judge have the ability under the new rule to simply say that a person is not credible or not, absent the circumstance where it's either absurd testimony or inconsistent with clear
Blatant, I think, is
clear testimony?
Under limited circumstances, as outlined in the U.S. Supreme Court's case in Scott versus Harris,
there has to be a blatant inconsistency.
Correct. So what the courts are looking at, and let me just say, when I want to reflect on the new standard and the summary judgment rule, it's because it's narrowed what is now defined as a triable issue of fact, right? And the two of the ways in which the rule has been narrowed relates to your question, which is that the new standard as to whether or not a reasonable jury could return a verdict for the non-moving party no longer allows consideration of purely metaphysical doubts or consideration of blatantly contradicted.
Let's look at it. Look at it from the other side of the coin, which is that credibility and intent remain a jury issue, even under the new summary judgment standard, unless the inconsistency is just blatant, unless no reasonable jury could come back and find that Ms. Gracia, wasn't intentionally misleading the insurance company. Why do we have that in this case? I mean, this judge really didn't seem to understand that distinction.
Well, I think he did, Your Honor. Turning, to the facts of this case, the trial judge actually had findings on the transcript of the hearing, as well as extensive findings in the order on summary judgment, which I'll walk through to demonstrate why it is that the judge reached the conclusion that he did. And the crux of the case was that the defendant presented uncontradicted evidence to support its request for summary judgment on its affirmative defense of a false material statement. And the plaintiff, for all intents and purposes, did not come back with any counter evidence. And within this uncontradicted evidence, there was undeniably objective evidence that established that the plaintiff had made a knowing and willful misrepresentation.
Now,
Not just
let me ask you about that.
Mhm.
In the deposition, she says, she was asked, did you read that, or was that something someone told you or you don't know? She says, I don't know. So my question to you is, first of all, is there any evidence that she even read the report?
I don't think she ever expressly testifies that she read the report, but you see, that's that metaphysical, possibility of doubt. She never gives.
That's Vargas and that's Treff.
In
which-
Vargas,
which-
what the court said is that it specifically did not consider this issue of metaphysical doubt because it wasn't raised by the parties in that case. So on remand, it has to be anticipated it was going to be raised in Vargas. And
Counsel,
so
the questions at the deposition are incredibly high level. They're very broad, pretty vague questions. I mean, how do we get there just based on that?
well, we don't. And the trial judge didn't. He expressly states in his order on summary judgment that he relied on 3 types of misrepresentations that the plaintiff made. The sworn proof of loss, as he references in the summary judgment order, the interrogatories, and the depot. And the interrogatories on page 1918, excuse me, of the record, the plaintiff is specifically asked, what damage evidence is she going to present at trial to support her claim? And she refers to the roof leak around the chimney, and she goes on to discuss the damage to the ceiling around the chimney. So that's another key piece of evidence that expressly contradicted the A and B report, of which she acknowledged that she was aware of. Not only that.
Would you agree that you can have an indication of prior water damage on your ceiling and still have a roof in good condition? It just means you didn't fix the interior damage?
You can, but the important point in this case is that the inspector testified that there was moisture present at the time. He expressly gave instructions to the home purchaser of the repairs that needed to be made.
Counsel, I'm sorry. I'm sorry. What I'm looking at the inspection report. Can you please point me to the page of the report that you're talking about that indicates existing moisture, just so we're clear?
I believe that those pages are cited in the brief, but I excerpted those pages, but I have not highlighted the reference
most
to
of the
existing.
most of the entries I read, so there was no moisture in the report.
Yes, I'm looking at page
There was
857, which says no elevated levels of moisture reading at
Okay.
the time of inspection.
I'm not sure that helps you that
Water
much.
penetrate. No, I'm just giving you the reference that
I do
is
recall.
one of those that you're asking for.
I do recall some ceiling damage that maybe there was some moisture, but it was related to HVAC.
Correct. So there's definitely the ceiling moisture. And so the key point also about the
But again, that
ceiling-
was related to the HVAC, so I'm not sure that helps you.
But that specific ceiling damage is what the plaintiff testified to in her deposition is the reason she noticed that there was a problem and that she needed to call and make a report of a claim. So in her deposition, she identified that she looked up and for the first time saw this ceiling damage by the chimney, and that's why she reported the claim. And so that's where you have 2 completely contradictory stories, right? You have the
What is the
undeniable.
damage? What does the damage look like now?
Well, see, and that's just plaintiff didn't present any counter evidence. We don't have a picture from the
Well,
plaintiff of
you
what
have
the
a burden,
evidence
right?
looked
You have a
like
burden
now.
You have a burden. How can a court evaluate whether the damage is the same? It seems like the trial
We
court
have
looked at-
we do have our engineer's report in here. And I believe that those are 2 of the photos that I excerpted and included in the answer brief. I think those come out of our engineer's report, and those are on page 1981 of the record on appeal. And it's identifying the moisture. And then on the prior page, I've referenced page 874 and from the end 848 and 57, which are the pictures from the A and B inspection report. And these are the pictures which the judge compared to determine that the plaintiff was seeking to advance a claim for the identical damage that had been identified in the inspection report in 2015. So the trial court, as I say, relied on all three sworn pieces of testimony that the plaintiff gave, which
You have
indisputably
responses to
overlapped.
interrogatories and deposition in the motion. I want to get back to the deposition a little bit. Since there's no evidence in the record that she read the report, is there any evidence as to who the report was prepared for?
Yes, the report on the face of it says it was prepared for the plaintiff. And although there's no affirmative evidence, she adopts and incorporates her opinions from the report into her deposition testimony. So even though she doesn't affirmatively say that she did or didn't read it, she provides sworn testimony about the report during her deposition,
But the word
giving
good,
the inference
the
that
word good can mean all sorts of things. I mean, is good enough where the lender didn't require repairs? That's possibly
Agreed,
used the
but
word good. Good enough where she was comfortable buying the house? That's appropriate. But I'm worried about the word good when combined with the fact that if she never read the report, or there's no evidence she read the report. So what does good from a report mean if you haven't read the report and you just heard it somehow? I mean, how definitive is the word good for purposes of showing an intentional attempt to defraud?
Well, I would say that
Because in your motion, you relied on two things: depositions and interrogatories. So I'm dealing with the deposition.
we also relied on the sworn proof of loss and its incorporation of an estimate that included the damage to the ceiling around the chimney. So plaintiff is on actual notice of the contents of this report, which she obtained for purposes of determining whether or not to purchase the property. And the only reasonable inference
what kind of
is
notice? Actual or constructive?
she's on actual notice because she was provided this report in conjunction with her decision that she
That's
ordered.
constructive notice, unless you've read it.
Well,
Constructive notice
purports-
means you should have. So, and
Her
the reason there's a
testimony-
difference between constructive and actual in this case, reason may be relevant, is if we find there's a requirement to show an intent to mislead. Because you're on constructive notice, it's harder to show fraud or fraudulent intent than if it's constructive notice versus actual notice. So,
right. Well,
I
believe-
noticed in your brief and in the order, the court's order, and I believe in the motion, it refers to notice. It doesn't say actual or constructive. And you just use the word actual here. Are you relying on actual, or are you relying on constructive, or are you just relying on the word notice and be non-specific?
No, I believe it's both actual and of course it's constructive, but to the extent that she, and I discussed this in the brief, that she testifies to the contents of the document and she ratifies her adoption of the information in the document, I believe the only reasonable inference to be drawn from that is that she had actual notice. But she also had actual notice of the condition of the ceiling. And she bought a house and moved into a house that had damaged ceilings. And she testifies in the deposition that she never conducted any repairs. And then 2 years later, she submits a sworn proof of loss based on damage to the ceiling around the chimney, which is the identical damage that existed on the day that she moved into the house.
Ms. Flowers, let me ask you this. If Ms. Garcia comes into that deposition and says, I don't know, I don't have a copy of the inspection report, you all probably never find it. But she doesn't do that. She comes in and says, not only did I have an inspection done, but I have a copy of it and I'll turn it over to you. That doesn't really strike me as the action of someone who's intentionally trying to defraud an insurance company.
At minimum, maybe it's a question of fact for the jury, right?
Well, but see,
Why couldn't the jury conclude that?
That's why there were questions of fact in cases like Anchor and Vargas, because what the plaintiffs did in those cases is that they provided counter evidence where they said, things such as, well, I didn't remember, or I didn't exactly get it right when I read the report. And see, so she completes the deposition, she goes back, she finds the report. Now we know she has actual notice, even if we had no question before. She finds it and looks at it to provide it to her attorneys. Her attorneys, as her agents, have actual notice of what's in the report, and she makes no attempt to correct her claim. These cases where summary judgment has been denied is because the plaintiff presented counter evidence. I forgot, I misunderstood. Oh, you're right, I'm going to take that part off of my existing claim. And we don't have the plaintiff.
She said there's not the same damage.
She does not say it's not the same damage. What she says in her affidavit is that there was damage.
I know what she says in her affidavit. A jury could draw an inference that she's saying it's not the same. I mean, I understand it wasn't as you would like it worded. I understand that. But are you saying that a jury could not draw an inference from that?
I think that when faced with the indisputable objective evidence from the inspection report, that the jury could not credit this testimony. And that's
going back to the
standard.
inspection report, I was interested in your photograph in 1981. I think the problem is I went back and looked at it again here while we were talking. I can't tell what I'm looking at from that picture. Are there any, and when I compare it to the inspection report, I mean, it's not clear to me what I'm looking at, that it's even the same spot. Is there another picture other than at 1981 I should be looking at as a comparison?
There are probably 75 pictures in the record.
Mhm.
And I would represent that I did believe that I was extracting the most accurate ones. 874, I guess that's the inspection report. And unfortunately, I don't believe I have all of the engineer's report pictures in front of me at this moment to be able to.
I guess the problem is if we're just comparing, low quality pictures from the 2015 report to itemized repair proposal, it becomes very difficult to compare those two and say, yes, this is definitely the same damage, right? Because you're comparing photographs, which aren't really that high quality anyway, to just sort of a written estimate of what's going to be repaired. That's why I asked, hey, was there in the summary judgment evidence, is there another picture that would clearly define this?
There are other pictures. I don't know that there's a clearer picture, but then there are also narratives and descriptions which identify the areas and discuss what the damage was.
Look, there's no doubt it seems like there's no doubt that there's stuff here for the jury to consider, right? Same area, damage in the same area. But, just saying that, hey, there's some damage around the chimney in 2015, and now there's a claim for damage in the same area, that alone doesn't seem to be enough to get summary judgment to me, even under the new standard.
Well, I understand what you're saying, Your Honor, but I don't know that that isn't considered when you read cases like Scott versus Harris, and they talk about, in that case, it was a video. And at some point, the goal of the new summary judgment standard is to provide fairness and bring cases that are meritless to a rational and an expedited end, so that the parties don't have to go through the expense of unnecessary litigation, and we don't have to provide juries, with questions where there's going to be, undeniable evidence that there was knowing and willful misrepresentation.
Are you suggesting no jury could find under these circumstances that Ms. Garcia did not intentionally try to defraud the insurance company? You think under these circumstances, no jury could come to that conclusion?
If the evidence was the same that it is today, where plaintiff did not affirmatively offer any counter evidence to explain why she made the representations that she did in light of the existing inspection document, in light of her moving into this house and living there for 2 years and knowing that there were ceilings damage that she never repaired, and many other facts that.
Going back to what Judge Evander was asking, I mean, why is one required to repair what one considers minor damage in the ceiling if the roof is not a problem. I mean, right? I mean, you could have a roof leak, repair the roof, and then just leave the drywall if it's not a problem for you, and maybe it's minor. Why is that? Why is that a misrepresentation?
Because the inspection report goes beyond that. The inspection report describes the roof being damaged to the extent that is going to continue to leak, and it identifies specific repairs which need to be implemented in order for additional damage not to occur. So it goes beyond just like you move into the house and you see the ceiling is damaged, but
which section are you talking about? Which section are you talking about? I think there is one section that says something like what you just said, but which one is that?
So I believe that I've got it pinpointed much better in the answer brief. However,
I only have so many screens and I have the report pulled up. So I can go back and find it. I do recall that most of the
like on page 844, it's recommending repairs to the roof structure. In a summary area, it's also talking about the chimney there. I believe,
again, you have some wood damage. If it's not structural, they may say, hey, you might want to repair this wood so it looks nice. But if it's not structural, why is a homeowner required to do so? Or better question, why is it fraud?
And like where it says that the chimney needs to be repaired and replaced to prevent moisture intrusion. Signs of past moisture intrusion, again, were visible.
Section are you at? What section?
Again, I'm still on page 844, which is just the summary. There are some more detailed, and it refers here on the summary to the pages of the report that it's summarizing from, which I know have more detailed information about that. But what the jury would determine.
Let me ask you this. There's,
yes.
I believe in the plaintiff's expert's affidavit talks about if a roof is damaged more than 25% under the code, the entire roof is to be replaced. Is that right?
That is the content, yes,
Right.
of their.
So if a homeowner has 10% of the roof damaged, and later on some event occurs and now they have 30% damaged, would it be fraudulent to say that when they only had 10%, it was good? The roof was good? I mean, at some point,
if they admitted that the 10%,
people who adopted the building code thought there was more than just a gradual difference, if you would, between some number under 25% and under 30%.
Mm-hmm. If the homeowner acknowledged that it was impaired to 10% prior to making the claim, and the claim is based on it having risen in its impairment from 10% to 25 or 30, then that's not a fraudulent claim.
That's a pretty sophisticated homeowner.
Yeah, and also if it's from 10 to 30, isn't there entitlement to a new roof? It's not just the 20%. I mean, you already have a wear and tear provision or depreciation provision, but where would that be?
That calculation of damages is separate and apart from application of the concealment or fraud provision. So just because that might be the accurate vehicle for calculating the damages, if we were to reach that point in the case, that doesn't retroactively eliminate a false material statement, which would void the policy, because
so you're saying
that
even if they would have otherwise been entitled to the new roof because they're over 25%, if they then on top of it just for good measure commit say something that's fraudulent, that they lose everything.
No, I mean, you're not, quote, otherwise entitled to it. The elements of a cause of action are presented in the proper order. And the first element of the cause of action, is establishing that you have a valid claim and that it's not avoided by certain affirmative defenses. So that's just taking the case in the proper order. You don't reach the damages question, which I understand completely the damages if we reach that, and how you would then be entitled to the entire roof.
Yeah, I just want to make sure that you do concede that there has to be an intentional misrepresentation with the intent to defraud. You do concede that as your burden.
Well, I haven't conceded that. First, two things. What they mean by intentional here, as I understand the cases, is that it's a knowing and willful misrepresentation. And that's the type of intent we're talking about. And because the trial judge expressly found that, he so stated in two places, once on the at the hearing transcript on page 2854, and then in his order on page 2326. So the court doesn't need to reach the issue, but if you did, we're not conceding it because U.S. versus Dickerson didn't involve the same policy language. You know, when you read that case, what you had was a one paragraph description.
And how about Vargas and Triff?
So Vargas and Triff go on to rely upon U.S. versus Dickerson, you know, even though it didn't involve the same policy language.
So you think those cases were decided incorrectly?
Well, so Johnson and Clark.
Is that yes or no? Were they decided incorrectly?
I think that it is certainly open to dispute, and they did not apply a proper textual analysis of the policy language, as was done by Johnson and this court and Clark. And I think that
Was Johnson an application case?
Well, so what happened in both Johnson and Clark, you had
yes or no?
Here.
Yes or
it's
no?
an application of the policy language, yes, because what happened was the defendant, the insurance company went to rescind under 627-409, and the plaintiff argued, oh, no. There's a higher standard. Because you wrote the policy this way in the concealment or fraud division section of the policy, you've committed to having to prove intent. So we don't have to be stuck with the no intent under the statute rescission provision. And so the courts were forced to examine the statutes.
Way over your time. I've given you a lot of extra time.
Thank you very much. I appreciate it.
Here, and we'll hear for the rebuttal.
Thank you.
Thank you, Your Honors.
I will agree, Ms. Flowers, that a lot of you going over time was the result of our questions.
So,
we don't blame you.
we don't mind. You saved us with a few hours drive today, so we appreciate that. So just to start, I just want to address really quickly. I understand the court is familiar with Triff and Vargas, and Ms. Flowers makes the argument that there was some type of additional evidence there that warrants the court here distinguishing these facts. Well, Triff unequivocally involved an inflated estimate that they later came back and said, no, I got estimates from 2 or 3 other roofers that were much less. So, and then Vargas, she testified in her deposition that she only had one claim from 2010, and later it was unequivocally proven that there was a 2013 claim, and that was proven through testimony from her prior carrier. And that's why I think this case is much different. We don't have a black and white, undisputed false statement. And I think we have to keep focusing on the two generic, open-ended questions that were not followed up on by the defendant during the deposition. And
how do you respond to
Ms.
Flowers' argument that, setting aside the deposition answers, the interrogatories and the sworn proof of loss are enough to support the summary judgment order?
So the sworn proof of loss is, there's actually deposition testimony from Mr. Cooprider. He did not rely on the contender estimate. So even in the answer brief, they concede that, if the Mr. Cooprider did not include the areas around his chimney, assuming that that's pre-existing damage, which we don't have any expert evidence before the court that it does. And second, when you actually look at the contender estimate, it has, line items to, repair the drywall and the ceiling and paint it. But, there's no evidence that wasn't done for continuity purposes. And there is evidence. It's on page 1083 of the record when Mr. Cooprider is asked specifically about his estimate, and he said that he did the items in the dining room and the family room for continuity of the ceiling. So, and also the sworn proof of loss was signed to the best of my information and belief. So it wasn't signed under the penalty of perjury. And as to the interrogatory answers, they adopt the contender loss, but later on it becomes clear that I don't think that there's anything in the contender estimate that is asking for prior damage, and there's no summary judgment evidence for the court that reflects that either. So There wasn't a deposition taken of contender. There wasn't any evidence that like I said, that wasn't continuity. Did I answer the court's question?
Yeah, you can continue.
Okay. Okay, thank you. And then, I understand that we keep talking about Scott versus Harris, but that's a video of a high-speed police chase. And there was an affidavit from the driver saying that he wasn't reckless. I utterly reiterate that these photos, I'm not an expert general contractor or roofer. I have no qualifications. And I can't look at those two photos and say that they reflect the same damage. And there's no summary judgment evidence before the court that says that either. So, all we have is the judge who decided that he didn't think Miss Gracia was credible. He looked at the photos and he essentially sat and weighed the evidence and entered judgment in favor of security first. So I think the appropriate thing would be to reverse and remand. I think that the records replete with questions of fact as to whether or not she even made a false statement. But I also think that the court in reversing should address the fact that if a jury decides the statement was false, it needs to be intentional and material. Thank you for your time.
Oh, thank you both for your time, and we will be in recess.
Thank you.